of the submission in Mr. Khan. Any interim order here?
I beg to mention for listing of a repeat
What is the matter?
matter about my lord illegal
Sorry? Auction. Who is auction?
illegal auction, my lord.
Who is auction?
My lord,
No, you have to tell the court what is the matter. You don't know.
actually,
All right, then who knows, send him, then we'll consider.
May I please, madam, with the consent of the petitioner, my lord, I beg to mention item number 25, my lord.
Yes,
Madam, be taken up after vacation, my lord.
item 25,
My lord,
on the prayer of learned counsel for the
a petition, my lord.
respondent made with the consent of the other side. This matter stands adjourned and shall now be listed after the puja vacation.
my lord, there is an interim in this matter.
Interim order passed earlier to continue. Check.
Come on, please.
May I present, Lordship? Lordship, I beg to mention for listing, Lordship. Lordship, matters regarding cooperative society, Lordship.
Listing for what?
Lordship, the board of society has been dissolved.
Listing for what?
Motion, Lordship, motion matter. So, Lordship,
Why it should be done tomorrow?
the board of society has been dissolved and one-man committee has been appointed, Lordship.
So what is the order you want? What order you want?
Lordship, one-man committee is
Hmm.
appointed, Lordship, because
When? One man committee was appointed when?
7/10/2023, Lordship, 7/10.
Bring it. Yes.
Yeah, we go, Lordship. I beg to mention a writ petition for listing, Lordship. A similar matter has been listed and disposed of by this honorable court, Lordship. The matter is about illegal encroachment of land by the government, Lordship.
Listing when?
Tomorrow, Lordship,
For
for
motion?
motion.
All right.
I am also praying for listing a matter repetition for tomorrow, Lordship.
What is the matter?
Motion.
What is the matter?
Regarding Cooperative society, Lordship.
Cooperative, what has happened?
Lordship, the respondent number 7, who is the ex-chairman of the society, he ceased to be the chairman of the society as per section 43(3). But he is still working as a president of this society, Lordship.
You file a representation before the register.
That is file that has not been considered. There is.
We'll see.
May I please, your Lordship? Lordship, I beg to mention item number 3. The learned senior counsel is undergoing treatment in Delhi. The matter
On
may
the
kindly
prayer of
be
learned
listed.
counsel for the petitioner, this matter stands passed over for the day. List for motion again after the reopening of puja vacation.
May you please, your Lordship, I beg to mention with regard to item number 15.
Yes. Item number
15.
15 has already been mentioned after puja. Yes.
Master.
May I pray for list? Huh? 15 has been mentioned.
15.
You want to mention 15? Yes. What do you want?
Lordship, my senior Mr. S.P. Chaudhary is out of station. Kindly adjourn the matter for the day.
On the prayer of petitioners council, this matter stands adjourned for the day. List after puja vacation. Yes.
Master, please.
Now, may I pray for listing of a vacating application and the reopening with I'm for the petition.
Yes.
Complies, Lordship.
Item 1.
Yes.
Please, your Lordship, I'm appearing on behalf of Mr. S.C. Cal.
Yes.
Respondent.
Why? This is for withdrawal.
My lord,
You want
this is
to
for
withdraw?
withdrawal, my lord, this is infractious.
Infractious. Why?
My lord, actually, we had appealed against our rejection for a settlement under the.
All right. You're Mr. Your name?
B. Sharma.
Mr. B. Sharma, learned counsel for the writ petitioner
Okay.
submits that this matter has become infractious and can be closed accordingly. Miss, your name, please?
Puja Khakolia, P. Khakolia.
Miss P. Khakolia, learned counsel. Representing Mr. S.C. Kyle, learned SC. GST, is it GST?
GST, service tax.
SC. GST authorities is present and does not have any objection if the prayer is allowed.
Of the lordship.
Much obliged.
Supplementary list for rural item 38.
May I please, lordship, we have a written instruction to judge this petition, lordship.
Mr. M.K. Hussain, learned counsel for the petitioner submits that he has instructions from his client to withdraw this writ petition. Ms. M. Burman, learned G. Assam is present. on behalf of the state and does not have any objection. The prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal. Yes.
Yeah.
Yes, what is this? This is second time.
My lord, charge sheeted case, my lord, already charge sheet has been, it take has cognizance taken, my lord. So
Then
at
you
this stage-
approach the court below.
My lord, at this stage, my lord, may I pray the LCR of the lower court may kindly be taken. My-
But
may-
lower
may
court has
be-
rejected your bail.
No, my lord.
Then?
My lord, by the order, my lord, it was, I take a lordship, the order, my lord, by
Hmm.
which, my lord, there is a serious apprehension, my lord, since I have been shown as a absconder in the charge sheet. Who is the police has no power.
No,
Now the
no.
POSCO and the 376 addend, my lord.
Mr. Hussain, I'm closing it.
My-
This is
give
a
it-
completely misconception. You have been charge sheeted, you want anticipatory bail.
Yes, my lord, that is, my lord, permissible.
All right, heard Mr.
My
Eke
lord,
Hussain,
after
Learned
access-
Counsel.
my lord, Supreme Court decision is there, my lord.
No, I'm not inclined to entertain this. You approach the trial court seeking bail.
My lord, kindly, Supreme Court.
Heard
judgment-
Mr. Eke
my lord,
Hussain, Learned
even
Counsel for
judgment
the
is-
petitioner.
Constitutional bench judgment is
By
there.
filing this application under section 438 of the CRPC, the petitioner has approached this court for the second time seeking pre-arrest bail. However, the fact remains that upon completion of investigation in connection with special bracket POXO case number 42 connection with, what is the PS case number?
My lord, Vilashipara PS case number,
You have not even
20.
mentioned the case number here.
I mean, it is there.
Vilasipara police case number,
Police case number, my lord, 210/2022. Page 11.
110 oblique 2022, registered under section 365 IPC, read with section 4 of the POXO Act. Charge sheet has already been submitted. And special bracket POXO bracket close case number 42/2020 has already been submitted against the petitioner. And special bracket POXO bracket close case number 42/2023 is pending before the Court of Learned Special Judge Bilasibara. Full stop. Under the circumstances, instead of entertaining this application for anticipatory bail, the petitioner must be asked to approach the learned court below seeking regular bail. As such, granting liberty to the petitioner to approach the learned court below, this application stands disposed of by providing that if such an application seeking bail is filed by the petitioner, the same be considered objectively after taking note of materials available on record.
One single line observation, my lord, please, I'll take a little pen, my lord, page 29. Bailable warrant was issued, my lord, page 29, for a moment. my lord.
Yes, what do you want to
My
say?
lord, that bailable warrant of rupees 2,000 was issued, my lord. But even then, my lord, apprehending, that is why the as per Appeals Court judgment I have before lord.
No, but
That may be taken into consideration, issuance of the bailable warrants.
no, what do you want? You want the court to say that grant him bail when he goes. Is that what you want?
But that's I.
Sorry, I'm not passing such order. Next matter, please. There are serious allegations against your client that he has molested a young girl.
My lord, he is a major, my lord.
All right, all right.
And medical report is, I have annexed the medical report also.
All right.
There is a no, my lord.
Yes, yes. Next, please.
Hello.
Yes. What is this matter?
What
What is your instruction?
Instruction was called for, my lord, with regard to the obstruction by the police while, my lord,
They are
opening the
denied.
shop, my lord. On the instance of the respondent number 4, my lord, who is there.
All right, then we'll close it by directing that he will not be disturbed, his operation of his shop shall not be disturbed except by following the due
Due
process of law.
procedure.
Mr. J. Payang, Learned Counsel, has appeared for the writ petitioner. The petitioner has alleged that the police from the Dhokua police outpost is causing undue interference in the running of his shop without there being any legitimate ground for doing so. Taking note of the full stop, taking note of the grievance expressed in the writ petition, this court had passed order dated 13/10/2023, requiring the learned government advocate Assam to obtain instruction from the respondent number 4, that is the officer in charge of Dhokwa Police Dhokwa Police Station. Accordingly, Miss M. Burman Lanet GA Assam has produced a copy of the written instruction dated 17/10/2023, issued by the Superintendent of Police Lakhimpur, which goes to show that there is no record of any interference by the police from the Dhokwa Khana Police Station in the running of the business by the petitioner. If that be so, nothing further survives for adjudication in this writ petition. Stop. As such, comma, by retaining a copy of the order dated 17/10/2023 in the record of this case, this writ petition stands closed at the stage of motion hearing by providing that the superintendent is which respondent?
Respondent number two.
That the respondent number 3 shall ensure that the police does not cause undue interference with the business of the petitioner without following the due process of law.
Item 5.
Undue to nalage interference with the business of the petitioner without following the due process of law. Yes,
May I please, my lord, the impugn notification has been
this
issued
notice will go, that's all. Nothing more at this stage. Heard Mr.
And,
B. Purkasth,
in the observation will be given, my lord, for the returnable date interim plan will consider.
heard Mr. B. Purkasth, Learned Counsel for the petitioner, peruse the averments made in the writ petition. Miss Tusi Sinha, Learned Counsel appearing for the
Respondent 1 and 2, tribal affairs.
respondent number 1 and 2, praise for some time instruction in the matter. NOM 6 weeks. Since Miss Sinha has appeared and accepted notice for respondent numbers 1 and 2, Miss M. Burman, Lanet GA Assam for respondent numbers 3, 4, and 5. And any CGC here?
Yes.
And Miss S. Borua, Lanet CGC for respondent number 7. Service of notice is deemed to be complete on respondent numbers 1 to 7. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction. Stop. Petitioner to take steps for service of notice upon the remaining respondents by registered post with ID within 3 days from today. Heard on the prayer of interim relief. Since the petitioner is alleged that members of non-Burman community, is it?
Yes, sir.
Non-Burman community has been included. Now, persons belonging to the non-Burman BARMAN committee from Kachar district have been included as members of subdivisional ST Development Board, Silchar and Lakhipur subdivision. The said prayer will be considered on the returnable date after service of notice upon the respondents.
Item 6.
Returnable date and after service of notice upon.
May I please, Your Lordship?
And subject to service of notice upon the respondents.
My lord, petitioner before your lordship is the, my lord, is the owner of a medicine shop, my lord. He was holding the, my lord, data for a long time, my lord, from 2007 by depositing advance to the,
This is a private dispute. Why have you come to read?
my lord, private dispute. What happened? A civil suit is pending before the court, my lord.
Hmm.
In the meantime, court has directed to deposit the rent before the through treasury salon. Accordingly, I am depositing the rent to through treasury salon. In the meantime, what happened? Suddenly she came and she put up the lock in my shop, my lord. And I have informed the police. Police has not taken action. My lord.
You ask for police help from the civil court. Heard Mr. JMA Chaudhary, Learned Counsel appearing for the writ
My
petition.
lord, I
I have two options, either to dismiss it or give you liberty to approach the civil court. Mr. Chaudhary, these things are going too far.
lost.
People are coming to writ court for anything and everything which is not maintainable.
In this case, what happened, my lord? The medicines which are, my lord, expiry is there, my lord. So I have submitted an FIR before the police. to
Yes,
take-
you have given a wrong advice to your client. He should have gone to the civil court earlier.
Civil court, my lord, petition is pending there, my lord.
You ask for police help there. Why have you, I'm not here. This writ court is not supposed to
Lost.
implement civil court's order. I'll mention, heard Mr. JMA Chaudhary, Learned Counsel for the petitioner, peruse the averments made in the writ petition. It appears that there is a private tenancy, landlord tenancy dispute between the petitioner and the private respondents, and the relief prayed for in this writ petition ought to have been sought before the learned civil court in connection with the pending suit bearing bearing title suit number 30 of 2020.
Yes.
However, instead of doing so, the petitioner has rushed to the writ court, filing this petition seeking relief against private individuals, which is not maintainable in the eye of law. Upor the Bahar, Mr. J. Hendik, learned additional senior government advocate Assam, appearing for the official respondents.
1 to 6.
Numbers 1 to 6. Private respondent number 7. Full stop. If the petitioner is aggrieved by inaction on the part of the police, it was open for him to seek an order of police help from the civil court, which the petitioner has failed to do. At this stage, Mr. Chaudhary, learned counsel for the petitioner, seeks leave of this court to withdraw his writ petition with liberty to approach the learned court below, filing an application seeking police help. Prayer allowed. The writ petition stands disposed of with liberty as paid for.
My lord, and the court below shall pass appropriate order.
Court below shall grant the relief, whatever he wants.
My lord, with an observation will do.
Nothing. These are all misconceived petitions. This should be dismissed with cost. I'm not doing it. Be thankful about it. Just like Nalage.
Yeah, please, the lordship. My lord, our village is included as an Adarsha village, my lord. However, my lord, on interference by the local MLAs, my lord, the schemes of our village, which has been going to sanction, this has been diverted to the other villages. Page 60, my lord.
The matters should be raised in the floor of the assembly,
My lord.
not writ court.
This is right, my lord.
No, I'm
However,
sorry.
my lord.
Sorry.
However, my lord, there is injustice is in regards to violation of the guideline, my lord. Adarsha village guideline is there, my lord. I have
These are
annexed.
matters to be raised in the assembly. These are not matters.
My
You
the
don't have any rights.
local MLA doing something different, my lord. The person who.
But it is
is
not
right
being
as-
made a party. But it is not being made a party over here.
My lord, yes, my lord, I have made the party, these MLAs also, my- this MLA, I have made the party also. And the person who is the local MLA, who is going to raise this issue before the assembly, he is doing this misdeed. He is doing
We'll
this.
have it after vacation and then we'll close it. Or Mr. H.R. Chaudhary, learned
My
counsel.
lord, notice may go at least, my lord, so that at least that
Sorry.
the government official can understand, my lord, whether.
No. This understand, you don't have to make government official understand through the writ. What kind of petitions are these? The writ court will now see which village should get what kind of fund and what kind of scheme. These are government schemes. You go and you make the top political executive and
These
Hesitative
are matter of records, my lord, so I am saying.
Mr. H.R. Chaudhary, learned counsel for the petitioner. After going through the prayer made in the petition, it prima facie appears that this is a matter to be agitated in the floor of the state assembly and not in a writ petition filed by invoking the jurisdiction of the court under Article 226 of the Constitution of India. Mr. N.K. Devnath, learned SCPNRD Assam, also submits that in view of the allegations made in the local MLA, the writ petition is not maintainable.
My lord, page six, my lord, kindly see page 62, my lord, page 62. Kindly see page 62, my lord, annex 6, my lord. This order I have challenged, my lord, 18/7/2023.
Yes. The local MLA is a party. Why do you say it's not been implemented?
Sorry, madam.
Huh?
I was actually wrong on that. I had heard
But this is not the first time.
first time, madam.
Keeps happening very frequently, is it?
First time.
You don't open the file before making a submission?
No, I had actually.
Mr. N.K. Devnath, learned departmental counsel has also questioned the maintainability of the writ petition. Be that as it may, on the request of Mr. Ahmed, this matter is posted again for motion after the vacation, so as to enable him to examine the legal issues.
Published.
May I please, the lord. My lord, the issue involved in this case is, my lord, payability of interest, my lord, upon the central excise
We have
refund.
to examine this issue.
Similar order has been passed, that may be passed.
Similar order has been passed.
Lordship.
What is the, where is the order?
110.
Page?
110.
So the learned judge says that the amount will be calculated in inform,
Yes.
that is after the judgment.
After the judgment of the Honorable Supreme Court.
So they are saying interest will be payable for the period after the
After
judgment,
the judgment.
not before that.
We
You are
said that-
agreeable to that order?
We said that we are entitled to interest from the date when the amount was refunded till it was returned.
So you are agreeable to this order?
Lordship.
All right. Which is the other item?
Item
Item
10.
number 10.
Item 8 and 10, same order.
Lordship,
Huh?
the dates, Lordship, reflected in the order dated Lordship at page 112, Lordship. In this case, my lord, in the present writ petition, item number 8, Lordship, date must be, my lord, 27/12/21. On that day, it was returned. Only difference. Lordship will find that page 112.
No, the order language will be different. We'll see. Take down heard Mr. S. Chetty, Learned Counsel appearing for the writ petitioner, also heard Mr. S. C. Kyle. Learned Standing Counsel appearing for the GST authorities, that is the respondents in this writ petition. Full stop. By filing this writ petition, the core question that has been raised is as to whether, now, before that you write. It appears that in terms of an interim order dated 7/12/2015 passed by the Honorable Supreme Court, directing
Notice.
the respondents to release 50% of the amount. 50% of the amount of refund payable under the Central Excise Exemption Notification number 32/1999, bearing number CE 33/1999 and 33/1999. দুইটারে পিছত CE লগাই দিব। The amount was refunded to the petitioner. However, subsequently, the SLP referred before the Supreme Court was dismissed by judgment dated 22/4/2020. As a result of which, the department is now claiming interest on the entire interest on the amount. The question that would arise for decision in this writ petition is as to whether the interest component would be payable with effect from the date of refund or from the date of the judgment and order passed by the Supreme Court, that is 22/4/2022. According to the writ petitioner, the interest would be payable only with effect from the date of the judgment, that is 22/4/2022. Mr. Chetia further submits that similar writ petitions raising the same issue is pending in the form of WPC number 3131 of 2023 is pending before this court, where an interim order is operating, and therefore similar relief be granted to the petitioner as well. First up, Mr. Kyle, Lannis SC GST is present and does not have any objection if a similar order as passed on 02/06/2023 in connection with WPC number 3131 of 2023 is passed in this case as well. In view of the above, issue notice of motion returnable in 4 weeks. Since Mr. Kyle has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Department Counsel. Are you appearing in this case?
Yes, ma'am.
Ms. Gayan for respond number 1 and Mr. Kyle for respond numbers
2 and 3.
2 and 3. No formal notice, extra copy will be delayed. Mr. Dibo heard on the prayer of interim relief, considering the facts and circumstances of the case, it is hereby provided that since the petitioner is willing to pay interest with effect from the date of judgment, that is 22/4/2020 on the refunded amount, the department to compute the amount payable on such count and intimate the same to the petitioner within through email within 10 days from the date of this order. First up, on receipt of such intimation, the petitioner shall pay the interest amount which will be subject to outcome of this writ petition. First up, the payment of the balance amount of interest so demanded shall remain stayed until disposal of this writ petition. Same order in item 10 also.
Item 9.
Till disposal of the writ petition.
May I please, your lordship. Lordship, the petitioners are the contesting candidates for the election of the Odali Samavai Samiti Limited, lordship.
So election has already been held
Yes, lordship,
and the candidates have already been declared.
declared lordship.
You have only option to file election petition now, nothing else.
Yes,
You can argue for 1 hour or for 2 minutes, but the result will be the same,
yes, lord.
correct?
Yes,
Because the ground you have taken here,
yes,
that there was some problem with the counting process,
yes, lordship.
that cannot set aside the election. The only way to do it is to file an election petition. That's the law.
Lordship, we have prepared an appeal also under section one hundred
In
eleven.
the, in the appeal cannot even be considered. I'm sorry to say, but the client should receive the right legal advice.
Yes, lordship.
That is one of the major reasons why there is piling up of cases and pendency of cases.
Yes, lordship.
If the correct advice is given, they go here, there, and then somewhere else they'll end up. You cannot set aside an election without filing an election petition. And there is a provision provided here, Rule 26 and 27.
Yes,
No other way out. Law is very firmly settled. And you also have a problem of limitations.
yes,
So it's game over. But you examine the issue. If you want, we'll have it after vacation.
yes,
You have understood the point. That's the law. Election cannot be interfered with lightly. The reason is, these persons carry the mandate of all the shareholders.
yes,
So just because you are unhappy, it cannot be done. There are set parameters on which and that is even if there is improper receipt of ballot,
yes,
improper acceptance of ballot, these are all grounds for setting aside election. This is what appears to be a ground.
yes,
But then the register doesn't have the power to do it. Nor will the writ court exercise 226 jurisdiction for doing. Yes, Mr.
My lord, the other ground, my lord, for non-maintainability, the return candidates are not implemented. Without hearing them, my lord, how can your lordship, my lord, adjudicate this matter? Non-joinder of parties, my lord.
That's lordship, we have.
But incidentally, no party is there. So my name is also not shown.
They are affected parties, my lord.
You have not invited them to the party. Mr. MK, Bora Learned Counsel for the petitioner prays for posting of this matter for motion again after the Puja vacation so as to enable him to examine the legal issues. On the face of objection raised by Mr. Talukdar as regards maintainability of the writ petition. On numerous grounds. Mr. S.K. Talukdar, Learned SC Corporation Department is present. On behalf of the official respondents, Mr. J. Avadin, Learned Counsel submits that although a caveat was lodged,
In favor, in respect of all the return candidates.
caveat was lodged by his clients who are the return candidates. His name has not been shown since they are not implemented as parties. Register to verify and tag the caveat with this case, and this is the matter again after Puja vacation.
Item 11.
May I please, your lord? My lord, the matter pertains to my lord.
This is a tender matter,
My lord.
tender matter.
No, my lord, they give applications for enrollment out to the portal, my lord. On the application, my lord, they are the applicants are provided with a username and login ID. Now, my lord, let me put the case, my lord. It pertains to the fitment of the speed limiting device onto the vehicles, my lord. The petitioner is a company, my lord, which manufactures the speed limiting device. Now, my lord, to be eligible, my lord, they have to obtain a certificate from an authorized agency that which they have obtained. And thereafter, my lord, they applied for the username and ID, my lord, but that has not been provided to the company. They applied in the month of September 2022. Now, we also put to challenge one order, my lord, by which the Assam government in the transport department, my lord, they have approved the proposal of giving a common user ID to all the manufacturers. Now, my lord, there are 42 manufacturers in India, my lord, and here in Assam, there are only 11 under one society. We have made them a respondent, my lord, in the respondent number 5. Now, what they are doing, my lord, since they are a society, now they are in a position to fix the prices, and a monopoly has been created in the market in Assam, which is in violation with the guidelines provided by the Ministry of Road Transport and Highways. We are putting to challenge that order, my lord, as well as the company is eligible for enrollment in the portal, my lord. They have applied, my lord, on September 22, my lord, last year, but the username has not been provided to the company, my lord. The whole idea behind is to create a monopoly of these 11 manufacturers under one society. So they fix a rate on their own, and if I may take your lordship for a moment, my lord, page 21, my lord. Page 21, my lord.
Yes.
Page 21, serial number 2, my lord. Am I with your lordship?
Yes.
After the approval means the certificate which is given by the approved agency, my lord. That it is annexed, my lord. NIC will issue a unique username and password to each speed limiting device.
So you want user ID and password?
My lord.
You want to enroll in the website?
Yes.
Which website?
My lord, that is a Vahan portal of the transport department.
What is your response?
Lordship may kindly have, there is a separation of material fact, my lord. Lordship may kindly have a look my instruction, lordship written instruction, the paragraph 7. They have not whispered a single word about the written application submitted by the petitioner on 19/8.
This matter cannot be decided in motion,
Lordship.
but pink flag is yet not yet open.
That
You want the court to open it? What is the pink flag?
I will file affidavit, my lord.
All right, you are appearing for whom?
For respondent number 1, lordship.
Respondent number 1 is CGC.
CGC lordship.
Had Mr. P.K. Moni, learned counsel appearing for the writ petitioner. The petitioner is primarily aggrieved due to non-consideration of its request to enroll in the official website within quotes Vahan, 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 as a manufacturer of wholesale speed limitation device. So Mr. Muni submits that the application of the petitioner has not been considered. Application of the petitioner for enrollment has not been considered only to create a monopoly amongst the 11 manufacturers in Assam for purposes which are not bona fide. Hence this writ petition. Ms. M.D. Bora, Learned Standing Council, Transport Department, Assam, on preliminary instructions submits that the writ petition has been filed by suppressing material fact in as much as the fact that the petitioner had withdrawn the application for enrollment earlier has not been mentioned in this writ petition. She therefore seeks 4 weeks' time to file an affidavit bringing the relevant facts on record. In view of the above, issue notice of motion returnable on 10th of November 2023. Since Miss,
M. Burman on behalf of Mrs. A. Gayan.
I'll record her name. Miss A. Gayan, Learned Counsel, Learned CGC has appeared and accepted notice for respond number 1. And Miss M.
And for 2, 3, and 4, my lord,
Respond numbers 2, 3, and 4.
5 is the private respondent.
Service of notice upon respond numbers 1 to 4 is deemed to be complete. Extra copies of the writ petition be furnished to the learned departmental council. Petitioner to take steps for service of notice upon respond number 5 by registered postal area. For now, you can take your pink flag and yellow flag back.
Deeply obliged, my lord.
Show it to him.
I have already obliged, my lord.
Supplemental list for motion item 39.
Please, Lordship.
Same also has been.
No, my lord, in this case, circle officer has reported that particular plot of land is within the expansion of Deeporville forest, my lord.
So give him the order.
Lordship.
In that portal, my lord, there is no such provision of having giving a speaking order, my.
But the statute says so.
But in this case, he is not pleading on that part, my lord.
Lordship, the instruction says that the land falls within the proposed extension for Deeporville. So there is no such law which prohibits transfer. So the stand of the revenue department will be necessary, Lordship, because the joint survey was conducted and the report was submitted.
Then we'll issue notice, sir, Mr.
That
Shri
is
Sarab Learned Counsel for the writ petitioners. The petitioners are aggrieved due to non-furnishing of a reasoned order. As to the grounds for rejection of applications submitted by them seeking NOC within quotes NOC for transfer of the land. On instructions obtained by Ms. Borua, Ms. Borman, Learned Government Advocate Assam, it is submitted that the land falls within the proposed expansion area of Deeporville. Deeporville, DEEPORVIL is within quote, and therefore no such permission can be granted. She also submits that since these applications are processed online, there is no scope for issuing, there is no scope for issuing any speaking order. Be that as it may, this court is of the opinion that the stand of the Revenue Department Assam will be necessary for disposal of this writ petition. As such, issue notice of motion returnable in 4 weeks. Since Ms. G. Hazarika, Learned SC Revenue Department Assam has appeared and accepted notice for respond number 1 and Ms. M. Burman for respond numbers 2, 3, and 4. Service of notice is deemed to be complete in this case. Extra copy of the writ petition before this.
Obliged, Lordship.
But Ms. Burman, you must tell them the statute says you have to give
Yes,
them.
I have already.
Then
committed.
portal has or not, without the portal, they will have to give.
They might have some.
They can't hide behind the portal.
Yes, my lord.
So, but for this Deeporville thing, because there is a division bench order now to develop Deeporville,
Examination is required.
and that is the reason we are going slow. Otherwise, this would have also been disposed
It
of.
can be
That-
examined, Lordship, if there is a bar, I would have no grievances, but there is no such bar as on date,
No, have you seen the order of the division bench?
Lordship.
I was a party to that bench. Now directions have been made to develop it as a world-class ecological reserve by making provisions for walking, cycling, boulevard.
Lordship.
All these things are now going to happen here. Boating facilities.
They can take a stand, Lordship, if there is a bar, I don't have any grievances.
Let them see.
All right, Lordship.
Item 40.
Wait, please, Your Lordship. When we're estimating the
So approval has been rejected.
reject on the count that when the notice was issued, the secretary who was there was ejected in the hearing
So we'll
subsequently.
have to issue notice.
Only difficulty which we formed the board, the chairman is the same, undisputed, register held it. Vice chairman is the same, secretary is the same, no difficulty. Page 59 at the moment, for a moment, there needs to be an interim protection.
That would amount to allowing the writ petition.
No, I'm not allowing the writ petition. Since the composition is not changed, since the very fundamental basic on which the order has been passed, that today X is the secretary. At that time, although Y was there, nothing wrong, but since today Y is not there, so your entire proceedings are rejected. D.
I will pass that order if you can show me the judgment. You have definitely not come prepared with the judgment.
No, I understand, my lord.
Lordship, also my petition.
If you want orders, you have to come prepared. Where is the judgment which says regardless of who holds the office, the fact that a wrong person is holding an office will not invalidate the action taken by him? Where is the judgment?
Get your point.
Without that, no interim order. And I have to see if that
Could-
judgment is there and
Could it be there on the reopening? my lord?
yes.
Reopening, sure.
I'll take instruction. A corrected copy may be provided, your lordship. In my copy,
Hmm.
some corrections are there, your lordship.
Mr. Banik, do some hard work. Just
Because
drafting something and throwing papers to the court will not
I
be
get the
enough.
point, your lordship.
so I'll take instruction in the
On
meantime.
6th,
666.
I had Mr. S. Banik, learned counsel appearing for the writ petitioner, also had Mr. V. Rajkumar, learned standing counsel cooperation department, Assam, who submits that a copy of writ petition furnished to him is not free from defect,
Yes,
as a result of which he could not obtain instruction in the matter. At this stage, Mr. Banik undertakes to furnish a copy of the writ petition to Mr. Rajkumar with a request to post this matter again on the date of reopening of the puja vacation. In view of the above, registry to list this case for motion again on 6th of November 2023. Go through the judgment. There are judgments of this court also, which may be of some help to you. Only in that case, you get an interim order, not otherwise.
May it please your lordship. My lord, this is a petition by the, my lord, a registered society of, my lord, 700 odd flat owners in the Games Village. And my lord, we are against an order by the GMDA asking us to remove, my lord, certain structures. These are not personal structures, community structures, like a community hall, a temple, a children park,
Where
etc.
is the order?
My lord, I think, my lord, in the facts situations, my lord, my first the question will be, my lord, GMD has no authority. My lord, lordship, it is followed by a show cause notice. It came before this court, my lord, and this court, my lord, without going into the merit, simply said that, all right, show cause notice, you bring it to a logical conclusion. Now they have passed this order. And in between didn't give me, my lord, show cause notice, your lordship will find at
No,
my
where
lord,
is the impugned order?
impugned order is here. Last page, page 129A. Annexure X. Whereas the High Court remanded the matter, whereas below, my lord, show cause notice was dated so and so. Below, my lord, whereas in terms of directions, the reply dated already, the reply was earlier, and after due consideration found to be untenable, rejected the following reasons. There never existed any wall as claimed by you as per records available with the authority. And the common road for the whole plot of land is to be used, my lord, for ingress and
Mr. Chaudhary, you are appearing for whom?
I am for the KV to restaurant number 4.
Hmm.
My lord-
You would like to file some affidavit perhaps?
Yes, but my lord,
We'll stop the demolition, no construction till
my
the
lord,
next day.
I'll try to resist that prayer, my lord.
let the
Because
vacation-
Your lordship
if
will
the
hear-
demolition is allowed, then the writ petition is dismissed.
So it does not, my lord. In my humble submission, the wall was never there. It
No,
was
no.
not there in the plan. And my lord, if it is demolished, and ultimately your lordship, my lord, finds that the demolition is wrong, it can be erected again, my
Who will
lord.
pay for it?
Anybody can pay, we can pay, my lord. But the question here is, my lord, there was never a wall and it's a road, my lord, given in the, my lord, plan, approved plan. It's a road. How can they block a road? And the, my lord, GMD is the owner of the land. I am a developer. Earlier developer has, my lord, constructed the flats in a part of the, my lord, entire land at phase 1. And the second phase has been entrusted to us. We are constructing, and that is the road, my lord, that was shown in the map, original approved map, when they were given. And when we were given, my lord, if your lordship kindly comes to,
So the wall blocks the road.
wall blocks the road, my lord.
No, my lord, in the backyard. Well, my lord, there are things to, my lord.
Wall
In
blocks
that
the
case,
road,
your-
my lord.
your
Also,
lordship will have to, my lord, even on the eve
also.
of the rush before vacation, my lordship will allow me 5-6 minutes to point out that they have handed over the entire, not only the flats. Kindly have a look at the, my lord, MOU signed with us, page 72. Page 72, not only wall, They have not given the schedule. There are other things, temple. And then there is a community hall. Kindly have a look at the impugn order. No schedule is given. No schedule, no specific description.
So, Mr. Borbora and Mr. Chaudhary,
My lord.
I have gone through the papers.
Yes.
You are free to argue, but I am indicating the order I propose to pass today. We will appoint a court commissioner who will inspect and submit a report.
Yes.
We'll have the matter on 7th.
Yes.
Till then, no further construction, but no demolition, except if there is an obstruction to the road, that can be cleared. That is the order we propose to pass, fixing the matter on 7th of November.
That will be better, my lord.
My lord, if your lordship gives me an opportunity to oppose, my lord. Firstly, my lord, the writ petition is not maintainable for two reasons. An appeal lies under section 71. And my lord, there are three petitioners. The petitioner number one is a registered society, which has, my lord, expired its validity. Petitioner number two is the secretary. Therefore, my lord,
Present secretary.
present secretary. So the registration has expired. Petitioner number three has not been described, my lord, who he or she is, my lord. So firstly, my lord, an appeal lies. And secondly, my lord, I'll show from their own document, my lord, there is a road existing. And it is only in, my lord, May 2022, they have ready the construction. Then the, my lord, GMD immediately issued the notice. Then they approached this honorable court.
See,
My lord,
Mr.
there was a fencing earlier.
Just a minute, Mr. Chaudhary. There is no difficulty in hearing you.
My lord.
Why 5 minutes for the whole first half? But the submission you are making,
My lord.
I must point out, it is not free from its own peril. Even if the appeal is to be preferred, the court will not allow the demolition to take place unless this writ petition is dismissed today itself.
That's
That you must be very clear, because otherwise, what is the purpose of this writ petition? So if you want to argue for final hearing today, both of you are ready, I am willing to hear. But either the writ petition will be dismissed or allowed. And you will be at a disadvantage.
I'll
because-
take the risk, my lord. Because, my lord, I'll satisfy, my lord. I'm sure I'll be able to satisfy your lordship, my lord. There was no wall. And my lord, because of that, because at this stage, my lord, your lordship will consider the, my lord, balance of convenience. The wall which was not there.
So if there is no wall, then why are we agreed by?
No, now they have constructed it and the GMD has immediately taken action.
There was a fencing, my lord, on, my lord, concrete base.
My lord,
And one more thing, my lord, GMD has no authority and jurisdiction. Kindly have a look to at page 73. It says, my lord, this is the memorandum with us. It says on handing over the management, they have handed over the management and my lord, the superintendents. Right on the common facilities and infrastructure developed for the township. They have entrusted everything on us, my lord. And they were supposed to construct a community provide.
Let us read the impugn order once.
There is no schedule either in the detailed schedule or specific schedule. Which part of the community hall? Impugn order is at, my lord, 129A. It is followed by, my lord, so cause is necessary to read, my lord. Kindly have a look at the so cause notice first, my lord. Can there be a so cause notice like this, page 118? Page 118 first, my lord. This is the schedule given. Page 118. Unauthorized construction of brick wall, my lord, already existed a fencing, and there were thoroughfare in the backward for the security reasons. There were trespasses by kettles. There were thefts committed, garbages dumped through the backyard. There was
So
fencing.
Mr. Chaudhary, in any case, before 27th of October, you cannot touch they cannot touch the wall.
And temple also.
On 30 days time has been granted, my lord. They
Yes.
could have preferred an
So
appeal.
why, we'll post it on 7th and just call for a report from the, from a commissioner, will appoint an advocate commissioner, will present a report.
Yes.
And we'll go ahead, then we'll fix the matter for motion.
Yes.
Why are you opposing that prayer?
Because, my lord, what happens, my lord, they have the existing flats and buildings there.
Hmm.
The construction of the second phase of the games village has been entrusted to us.
Hmm.
And we have been using this road. This road has been shown in the maps, my lord, they have annexed also. And now it is.
These are
no, that-
independent
no, let
blocks,
me complete.
independent block.
No, it's not independent. It's an integrated project. But I'll show it's an integrated project. Phase 1 was complete. Phase 2 has been entrusted to us. And because the road has been blocked, my lord, the purchasers of the flats, they are now, my lord, they are reluctant to pay, and there has been arbitration proceeding against us.
So they have alternate road, I can show. They were earmarked
There
road
is
for
no
them.
question of an alternate road.
There
Your
are-
lordship will see the map, my lord. I have given the map. Your lordship will find, my lord, in the plan itself, it is clearly shown as a road.
It is their own plan,
It's a-
my lord submitted. A road goes like this. They wants to have access to both roads. The 700 Games Village and the other road also.
This
So
is
that
a, my
the
lord,
valuation increases.
40-meter road, my lord, and
Yeah,
the
you-
buyers are not there now.
Huge construction company.
Where buyers have gone to the, my lord, arbitrator.
That is a different thing. That is their.
That is why, my lord, the balance of convenience I was submitting. my lord.
3 towers they are constructing, my lord. They have their
It's
road.
a
and
clear
approach,
road in the
earmarked.
map, my lord.
It is their own
Map
map.
they have annexed, my lord, there is, the road is shown.
It is their own
It's a
road.
metal road.
So it is their own road, own map, my lord.
It's a road of the, my lord, the GMDA.
They have been provided with the road, my lord. And we were allotted this, my lord, Games Village way back in 2008.
Yeah, phase one was
And-
complete. The phase one,
And
the
my lord,
phase
the
two has
community
been.
center, children's park, these we have, my lord, created, my lord, only at the earmarked and designated places. As per, because JMDA failed to provide for all these years. And
Your lordship,
can
will, my
there
lord,
be a
have-
schedule like
have
this?
marked it, colored it in order to understand, my lord, but the black and white, your lordship will see, my lord, the road has been, or metal road has been indicated, my lord, in the plan.
Not this road.
It's a metal road. Have a look.
These are all, my lord, we have denied all these things. This is the case of this, my lord.
If it is, my lord, the denied, my lord, it's a disputed question of fact.
No. Apparently, in the schedule, it is not mentioned. And the official map also I have annexed. At my lord, page 44. In the
Page
back-
44, the map that has been, that has tried to give a, my lord, lopsided picture. A projected, a lopsided picture, my lord.
Show cause notice, where is the show cause?
So cause notice, my lord, page 118. Kindly see the schedule below. Kindly see can there be a schedule without any specification like this, my lord? 1, unauthorized construction of brick wall within the integrated campus of Games Village, thereby causing obstruction for ingress and egress to the earmark site for phase 2.
My
Phase
lord-
2 land is different. The agreement with GMDA and this Simplex company, there is no provision for such ingress and access, number 1. And secondly, unauthorized construction of temple near the main gate, unauthorized occupation, construction, development of structures and park, which structure they have not given.
We are concerned with the wall only, my lord.
It will be a point for adjudication in the construct initial promise made by GMDA while selling those 700 flats. They put it on public, my lord, their brochure, where the promise was made that these amenities will be created by them. Kindly note, no separate descriptions given, mention at all. Which structure, which park, description of the brick wall in question, standing on what foundation, which stretch of the wall, nothing has been given. It was bounded, my lord, when initially it was sold to us, it was bounded, entire, my lord, village. And
My
the-
learned friend is submitting as
This
if, my lord, the petition number 1 is the owner of the land. Owner of the land is the, my lord, GMDA.
owner of the land, my lord, management has been handed over to the 700 flat owners, and at the behest of GMDA, we formed a registered cooperative society. I have stated, my lord. Because 700 flat owners, certain community amenities are essential, my lord, and GMDA was supposed to create those. They failed for years. And now, my lord, this company is being, my lord, favored by GMDA officials. I have made specific allegations against that, my lord. So this cannot be a schedule in the eye of law. And moreover, in view of the fact that the entire management and the social amenities for supervision, we were handed over, entrusted. So GMDA has no authority to, my lord, issue a notice under GMDA. Authority ends there, my lord. The moment way back in 2013, they entrusted, my lord, the entire social amenities to us for supervision and, my lord, creation.
Mr. Sharma, M. Sharma, be in the court for a little while. Be here. Mr. Chaudhary,
My lord.
I have made up my mind.
In spite of, my
We'll-
lord,
we'll
there being
extend
an
the-
appeal. In spite of there being a provision for appeal, my lord.
Sorry,
Provision for appeal, my lord.
we'd just like to have the independent view through a commissioner. We'll submit a report and no further of, just the 30 days mentioned in the impugned order. We'll extend it till 7th of November. That's all. Just awaiting a report by the commissioner. Let him give a report on all these controversial contested facts. That will be good for your client also. If we remand it to appeal also, then also the order will be stayed. Because we can't pass an order leaving the petitioner high and dry. You may be correct. So the shortest way is to get a view through an independent commissioner. And on that basis, take a decision whether the court should put its hand in this or not.
My client is my lord, anyway, my lord.
You can't wait for 7 days, is creating a real, the court, you know how the court functions.
I'm okay.
Till 27th, you can't even touch it.
True.
So another 10 days,
My lord.
heavens will not fall.
Yes.
What the court is proposing is not unreasonable. It's a balanced approach. Let us have the report of a commissioner on these issues, which with whatever is flagged, and this will be an independent report. We will submit it and we will take that into account, hear your submissions and pass in order. If we find that, so the commissioner will visit the site, carry out inspection, prepare a report and present to the court. Some charges have to be paid to him, which will be shared by both sides. And I propose to appoint Mr. M. Sharma as the,
My lord, one thing, otherwise he's a nice fellow, son of my erstwhile good old friend Bhaja Sharma, but he's a permanent junior of Mr. Chaudhary.
actually, he's a junior.
Permanent junior, my lord. Otherwise, nice fellow.
And that may not, yes.
Otherwise, nice fellow.
Mr. Khan? What about Mr. Khan? He is not connected.
I cannot
be in this case, madam.
You are,
Since GMD is involved, I cannot be there.
you cannot be there. Who else, who has a little understanding of the civil? All right, we'll think of a name. We'll think
Lord,
of
I
a
will
name.
leave it to your lordship.
Take down her, Mr. S.C. Borbora. Take learned additional senior government advocate Assam as well as Ms. G Hazarika, learned counsel appearing for the.
Lordship, mentioned that this was sent to the my lord revenue Bureau for sanctioning the amount. Lordship. It was not sanctioned. It was sent.
Preparing for the revenue department. The learned departmental council submits that the proposal for sanctioning the amount
4
for
lakhs.
release of ex gratia relief in favor of the petitioners have already been sent to the revenue department, but the same has not yet been sanctioned. On such ground, Mr. Handick prays for posting this matter again after the reopening of Puja vacation, so as to enable him to, so as to give him one final opportunity to obtain instruction in the matter. On the request of learned departmental council, this matter is directed to be listed again after the reopening of the vacation, so as to enable them to obtain written instruction in the matter.
Lordship.
Declare.
her by the investigating officer in connection with Bilasipara PS case number 337/2023. It appears that the immovable property bracket office building in question, bracket close, in question, was seized by the IO in Bilasipara PS case number 337/2013 in presence of executive magistrate. But even after completion of investigation, the building has not been released. Full stop. The petitioner is the owner of the building, but and she has nothing to do with the alleged offense. Notwithstanding the same, the petitioner has been deprived from enjoying her property. Mr. Saikia, learned counsel for the petitioner, by referring to the decision of the Supreme Court rendered in the case of Nevada Properties Private Limited through its directors versus State of Maharashtra and another, reported in 2019 bracket close 20 SCC 119, submits that an immovable property cannot be seized by the IO in connection with investigation in a criminal trial, in a criminal proceeding, in a police case, not criminal, in a police case. Notwithstanding the same, by order dated 9/12/2022, the learned SDJM, is it learned judicial magistrate? Subdivisional judicial magistrate, bracket M, bracket close, Bilasipara, has rejected the prayer of the petitioner on the ground that the sealed office within courts cannot be opened without the consent of the executive magistrate. First up, Mr. H. Sharma, learned additional senior government advocate, Assam, has submitted in his usual fairness that after the decision of the Supreme Court in the case of Nevada Properties Private Limited, bracket Supra, immovable property cannot be seized under section 102 of the Code of Criminal Procedure. Full stop. In the case next, in the case of Nevada Properties Private Limited, Supra, the Honorable Supreme Court has categorically held that the expression within quotes, any property, unquote, used in subsection 1, bracket close, of section 102 of the Code of Criminal Procedure, 1973, would not include immovable property, and consequently, a police officer investigating a criminal case cannot take custody of and seize any immovable property which may be found under circumstances which create suspicion of commission of any offense. Full stop. If that be so, the seizure of the office building apparently appears to be illegal. Be that as it may, since the investigation has already been completed and the respondents do not have any requirement, do not have any objection if the seal of the office premises is removed by this court, this writ petition is hereby disposed of. Who is to pass that order?
As because it is before the SDJM, Lordship. The SDJM
Disposed of
Bilasipara.
with a direction upon the SDGM Bilasipara to review the order dated 9/12/2012 and pass fresh orders in the light of the observations made in this case. The aforesaid exercise shall be carried out as expeditiously and within 2 weeks from the date of filing of a fresh petition by the writ petitioner by enclosing a copy of this order. Writ petition stands disposed of.
Like
Lordship, in this matter, in compliance of your Lordship's order dated 13/10, last order, I have shared the communication between the joint secretary.
What has happened?
Lordship, we have received the fixation of ceiling. Lordship, within the period of, within 10 days, we'll release the amount, Lordship. So if Lordship may fix a date immediately after vacation, my lords, till then,
Mr. N. Hawk, learned counsel for the petitioner is present.
Lordship,
In terms of the order dated 13/10/2023, Mr. Chalia, learned SC Finance Department, Assam, has obtained instruction and submits that within 10 days from today,
Yes.
the amount which has been sanctioned by the Corporation Department,
FOC proposal, Lordship,
the FOC proposal,
the amount will be released from our end.
the amount under the FOC proposal sent by the Corporation Department shall be released in favor of the petitioner.
Lordship,
Taking note of the said submission of Mr. Chalia, this matter is directed to be listed again on 8th November 2023 as a fixed item.
Lordship.
Item 33.
In this matter, my lord, we have yet to receive the extra copies. We cannot pick up the.
What is this matter about? None appears for the petitioner. Ms. MD Bora, yes.
My lord, actually, this petition is unmaintainable, my lord, because he has filed a writ petition seeking a direction from this honorable court to obey the direction of the deputy commissioner. This is not a PIL also, my lord. The prayer portion, Lordship, may kindly
None
have a look.
appears for the writ petitioner on call. Ms. MD Bora, learned SC Transport Department, Assam, submits that the writ petition is not maintainable.
My lord.
Ms. M. Bora, M. Burman, learned G. Assam, has also made a similar submission. Full stop. I find that this writ petition has been filed seeking a direction upon the authorities to issue further direction to the commercial passenger vehicles at allotted space. To issue further direction to the commercial passenger vehicles to be parked in the allotted space only and not besides the NH 15 of Gogamuk town, causing traffic congestion and inconvenience. Full stop. The aforesaid aspect of the matter is required to be looked into by the district administration as well as the police administration of the district. Therefore, without expressing any opinion on the merit of the case, this writ petition stands disposed of by providing that the petitioner may submit fresh representation before the
Deputy
Respond
Commissioner and Superintendent of Police, 2
respondent
and 3,
numbers 2 and 3.
my lord.
Ventilating his grievance in the matter. If such representation is submitted by the petitioner by enclosing a copy of this order within 4 weeks from today, the same be looked into and appropriate action as may be warranted in the facts and circumstances of the case, be initiated therein. Full stop. Writ petition stands disposed of accordingly.
Deeply obliged, my lord.
Item 34. This is for personal action.
Lordship, may I place the facts in short, Lordship?
Yes.
His personal appearance is there, Lordship. The petitioner of the father of the petitioner, there was a FT case was pending against him. During the pendency, he is expired. So accordingly, the FT, the Foreigners Tribunal passed an order, the case is filed. Thereafter, Lordship, the one of the brother, this is the present petitioner, has placed the for renewal of his passport, he has placed the passport of his brother, that is the present petitioner. The person who placed that for renewal, he was Abdul Kalam Patwari.
Just a minute, just a minute. No, first of all, who
Yes,
is present, who has come? What is his name?
My name is Inspector Performance.
No, why he did not respond to the government advocate's request for furnishing instruction? It is reflected in order dated 6/10/2023. Why is that?
Today, Lordship, regarding.
No, he has to answer that first. When the court asked the government advocate,
According to him, Lordship, he has not received that letter, whether it was.
no, you see the order dated 6/10/2023.
Lordship.
The government advocate was given 1 hour time to again contact. Still, he has not given any proper reply. Why is that?
Regarding that part, Lordship, also, I'm. আপনার ফোন করেছিল অফিসার ইনচার্জ আপুনি নহয় জানো আপোনাক ফোন কৰা নাছিলে
And this passport has been seized. Why?
That is, I am placing Lordship. The case was filed by the Foreigners Tribunal against the father as because he died, Lordships. Thereafter, Lordship, the one Abdul Kalam Patwari, who is the brother of the present petitioner, he is applying for renewal of his passport by placing the passport of the present petitioner. And as the FT has passed an order by making it filed, but against that, Lordship, there was a case before this honorable court, that is WPC number 7526/2017, whereby this honorable court has held in paragraph 15, Lordship, I am placing it. Just now I have. This, because of this, Lordship, the whole things, to my knowledge, Lordship, it came. Paragraph 15. I have marked it, tick marked it, Lordship. That's because that is the instruction I received, Lordship.
No,
So
is there a proceeding in the FT against the petitioner?
No,
Then
no.
why his passport?
That is the, as because Lordship, he is the son,
Hmm.
they were under the wrong notion, but against the present petitioner, he has been declared as an Indian citizen, Lordship. That goes,
Why his
Yes.
passport has been seized? That's the question I'm asking.
Lordship, because of this order, they are relying on this paragraph 15 of this honorable court order.
Hmm.
As because he is the son,
Hmm.
so the reference case cannot be stopped there. Accordingly, his passport was seized and it was placed before the passport authority. It was placed before the passport authority, but he has already been declared as an Indian citizen, Lordship. That is the wrong they have committed. Yes, Lordship, they have committed the wrong.
Let them file an affidavit. We'll consider payment of compensation. Not much, maybe 20-25 lakhs, which will be recovered from his salary and pensionary benefit.
And according to him, Lordship,
Hmm.
he was directed by the officer and he placed it before the.
No, let him file an affidavit. And then we'll see, because this is, the
Lordship.
police cannot act in their ipsy-dixy. Under what authority of law he seized the passport?
Lordship. No, because of that wrong notion, Lordship.
Wrong notion is their problem. We can't help it. Take down hard Mr. B. Chandra, learned counsel appearing for the petitioner also, and Mr. H. Sharma, learned additional senior government advocate Assam appearing for the state. The officer in charge of Hojai police station, namely, what is his name?
Tapan Medhi.
Upon Medhi is personally present before this court in terms of the order dated 6/10/2023, passed in this proceeding. First of, the passport of the petitioner bearing number 587636664, issued by the Ministry of External Affairs, Government of India, has admittedly been seized.
May I place one thing, Lordship?
Yes.
If your Lordships come to paragraph 6 of the writ petition,
paragraph
what-
6
what
of
do
the
you
writ
want to say?
petition. The petitioner begs to state that thereafter the Ministry of External Affairs, Government of India from its regional passport office in Guwahati sent letter dated 25/4/2023 to the petitioner, impliedly accusing him of suppressing, providing wrong information in his passport
All right, well,
application.
you file your affidavit,
Lordship.
so and so. Seize the passport of the petitioner bearing number so and so issued by so and submitted it before the passport authority. Full stop. Alleging that the impugned action is without the authority of law. The writ petitioner has approached this court by filing the instant petition. Full stop. When the court had inquired with the police officer present before this court as to the reason for seizure of the passport, no convincing reply could be given to the court. Full stop. There is also no dispute about the fact that the petitioner is a declared Indian citizen and there is no allegation of any wrongdoing on his part. Full stop. Under the circumstances, the action on the part of the police in seizing the passport of the petitioner prima facie appears to be without the authority of law, and therefore it may be a fit case for considering as to what further action should be initiated against the wrongdoers, including issuing direction for payment of monetary compensation. Full stop. However, before considering such an order to be passed in this proceeding, this court deems it appropriate to direct the superintendent of police, bracket B, bracket close Hojai, that is the respondent number 3, and the officer in charge, Hojai Police Station, Hojai District, Assam, respondent number 4, to file individual affidavits, individual personal affidavits in this case, responding to the grievance, responding to the allegations made in the writ petition. The affidavits be positively brought on record on or before 22nd November 2023. The personal appearance of the office police officer stands dispensed with for the time being, and the matter shall be reviewed after the affidavit is brought on record. Copy of this order be furnished to Mr. Sharma. Let them file personal
Lordship,
affidavits.
apart from that, I think his passport can be released, Lordship, in the meantime. Let them file their affidavit, Lordship, as because the passport authority has been made a party, I think.
The next, since there is no allegation against the petitioner and Ms. K. Pukan Lanet, CGC submits that the passport of the petitioner can be released. It is directed that the petitioner shall be handed over his passport within 10 days from today. Copy of this order shall be furnished to Ms. K. Pukan and Mr. H. Sharma, Lanet G. Assam, Ms. K. Pukan, CGC and H. Sharma, G. Assam, during the course of the day. Appearing for the respondent number 5. Yes.
Item 35.
It relates to ex gratia malad 2 lakhs rupees malad as per the government notification.
No instruction.
Lordship may dispose of since they will make inquiry and accordingly they will do the needful malad. That order already I have annexed of this honorable court matter.
I had Mr. B. Chetri, Lorry Council appearing for the writ petitioner. The petitioner is the wife of deceased Nanu Pradhan, who died in a road accident on 15/8/2022. While riding what?
Scooty
Riding
malad,
a two-wheeler.
2-wheeler scooty malad bearing number AS 02G.
Full stop. While riding a two-wheeler in the road from Hosai to Nagaon the petitioner was hit by a Tata mobile carrier bearing, while riding a scooty bearing number AS-02G-233, along with his friend Hussein Ali. The two-wheeler was hit by Tata mobile carrier bearing number AS-02CC-8758. The petitioner suffered grievous injuries. Petitioner sustained, the husband of the petitioner sustained grievous injury, which ultimately led to his death. An FIR was lodged on 01/09/2022, based on which Nagaon PS case number 470/2023 was registered under section 279/304 bracket capital A of the IPC. Full stop. Mr. Chetri submits that as per the standing government notification dated 15/11/2014, the petitioner, being the wife and next of kin of the deceased, is entitled to ex gratia relief of rupees 2 lakhs. However, despite request made by her, no such amount has been released till today. Hence this writ petition. Ms. N. Bordoloi, Learned, Standing Council Revenue Department Assam, and Ms. M. Burman, Learned, GA Assam, have submitted that they are yet to receive any instruction in the matter. Full stop. Since the petitioner is seeking ex gratia relief and there is nothing to dispute her claim, hence, instead of keeping the writ petition pending, I am of the opinion that the matter can be disposed of by issuing a suitable order. As such, this writ petition stands disposed of by directing the concerned authorities to inquire into the matter, and if found to be genuine, the claim of the petitioner for release of ex gratia compensation of rupees 2 lakhs be processed. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. Writ petition stands closed.
Is also same, my lord, only the date is different.
Wife of Tilak Saikia, who died in a motor accident on 4/6/2019. Rest to see the changes disposed of.
Look, I have received some instruction. My lord. That is regarding the procedure to be followed for in case of deputation, my lord. Yeah.
So that is the procedure.
That is a my lord, here, my lord, that the first, my lord, state government have to take the steps, my lord. Then this is forwarded to the central government, my lord. My lord, whether they have taken any step, my lord, that may be conveyed to us, then it is. My lord, as per clause 7, my lord, as per existing procedure of the deputation of the foreign nation issued by guideline dated 24/4/2014 and 1/7/2000, in all cases where the foreigner is arrested and action is taken under the relevant act, the foreigner can be deported only after completion of the sentence court proceeding. In such case, the foreigner can be deported by the state government, FRO concerned immediately on completion of the sentence of the court proceeding if he or she has a valid travel document, passport, and subject to other court case pending against him or her, and there is nothing adverse against him and her. In case of foreigner does not have valid travel document, passport, it is necessary to obtain the requisite travel document from the embassy, high commission of the country concerned before he or she can deported.
In such cases, the state government, UT administration, FRO concerned may take the matter regarding the issuance of the travel document in favor of the foreigner with the Ministry of External Affairs, Patiala House, NS Tilak, New Delhi, so and so, with a copy of Ministry of Home Affairs, Foreign Division, with detailed particular and photograph of the said foreigner immediately on arrest of the foreign nation on or filing the FIR, whichever is earlier, my lord.
All right, take down, heard Mr. L.R. Mazumdar, learned counsel appearing for the petitioners. Also heard Ms. A. Gayan, learned CGC appearing for the respond number 1, and Ms. M. Burman, learned G. Assam appearing for the respond numbers 2, 2, 2, 3,
3 and 7, 2, 3, 4 and 7, my lord. Represented by FD council.
we'll make it 2 to 7, yes. None has appeared for the respond number 8, full stop. It appears from the pleadings that the lead petitioners herein are Bangladeshi nationals who were prosecuted under the
In the court of lordship, under like section 14C.
Under
and-
section 14 bracket C of the Foreigners Act 1946 and convicted by the court of
Lordship, learned Chief Judicial Magistrate Karimganj.
Learned
A-
Chief Judicial Magistrate Karimganj. The petitioners were sentenced to undergo simple imprisonment for 4 months without fine by order dated 15/12/2017. Last up. According to the petitioners' counsel, all the 4 petitioners have completed their sentence in the year 2018.
17AC.
So on 15/12, they were sentenced, and
Uh,
in the December only they have completed 4 months.
Lordship, before the trial lordship, they already served 3 months.
Acha. And already served this sentence several years back. But notwithstanding the same, the petitioners have not yet been deported and are languishing in the jail. First of taking note of the case of the petitioner, the learned CGC was asked to obtain instruction from the Department of Home Affairs, Government of India. Today, when the matter is called up, she submits that as for the office memorandum dated 16/10/2023, issued by the MHA, it is the state government of Assam which is required to take action in the matter. First of, Ms. M. Burman, learned G. Assam, submits that she does not have any instruction in the matter. First of, considering the nature of grievance expressed in the writ petition and also the allegation made by the petitioner's counsel, his writ petition is directed to be listed again on 20th of November 2023. The respond number 2 shall file affidavit on or before 17th November 2023, bringing the stand of the state on record. It is made clear that pendency of this writ petition shall not be a bar for the authorities to take appropriate action in the matter in accordance with law, if so advised. Let a copy of this order be furnished to Ms. Burman during the course of the day.
Obliged.
For hearing item 43, supplementary.
Yes.
I was also directed to file written submissions along with judgments.
I for the respondent number 4, my lord.
Yes, just 1 minute. So we'll fix a date of hearing. When do you want it? Dr. Ashok Saraf, learned senior counsel appearing for the writ petitioner. Who is for the respondents union? Also heard Miss A. Gayan. Who is appearing? Miss Gayan? For the Union of India, who's appearing? You are appearing for 4. And who's for 5 and 6? And Mr. Sharma, you are for response number 7.
7, my lord. I'm appearing for 7.
So we'll fix a date of hearing. Can you?
Very
agree
well.
on it? When can we fix a date? Acha, you're so and so, Miss A. Gail, Lanet CGC appearing for the response numbers 1, 2, 3, 5 and 6. Comma, Mr.
V Kumar.
V. Kumar, Learned Counsel for the response number 4, and Mr. P. Sharma, Learned Counsel for the respondent number 7, who is present in the proceeding through remote video conferencing bracket RVC from New Delhi. Full stop. As per the order dated 19/9/2023 passed by this court, the petitioner has submitted written arguments. Similarly, the respondent number 4, you have also submitted respondent number 7.
Yes, my lord. We have also filed.
Respondent numbers 4 and 7 have also filed their individual written arguments. The same be retained in the record by in a separate folder. Full stop. On the request of learned counsel for all the sides and as agreed to by them, this writ petition be listed for final hearing on, when do you want it?
First week of December, my lord.
On the 4th of December 2023 as fixed item. It is made clear that if necessary, the writ petition will be heard on day-to-day basis so as to complete the hearing expeditiously. Parties to
So
come
great.
to-
So great.
Yes, that's all.
All
right. That's all.
Interim order partially continue.
That is there. That is.
No,
What
interim
is the
order.
earlier? What is the earlier? Let's see. Interim order is not limited.
Well,
Interim order passed earlier to continue until further orders. Yes.